When I was questioning this doctor in a medical malpractice deposition, his attorney kept objecting to almost every single question that I asked. What happened when I went ahead and said, I'm busting this deposition? Do I give up my right to continue questioning the doctor? What happens then? You want to know the answer? Come join me on this walk through the neighborhood as I share with you exactly what happened. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, this is a medical malpractice case where my client sued her doctor, claiming that the doctor was careless and caused her significant harm and injury. We had a medical expert to confirm that we had a valid case. So now, during the course of this lawsuit, I had an opportunity to question the doctor whom my client was suing. During the course of questioning, which took place in the attorney's office, the attorney was nasty. The attorney was obnoxious. Every single question, almost every single question that I asked the doctor, the attorney objected to. Even simple, straightforward questions such as, hey, Dr. Jones, on January 1st, did my client come to see you? Objection! Really? You're objecting to that? What's your objection? And now the attorney would start arguing with me. And this kept happening over and over and over again. Is that appropriate? No. If the attorney is going to make an objection, he's going to do so for one of two reasons. Either he really believes that the question is improper or the topic is improper, or, more likely, what was going on in this case was he wanted to distract me. He wanted to get me off track so I wouldn't remember what question to ask next. But this was a pattern. This kept going on for not one, not two, but 3 hours. And it was frustrating. It was aggravating. The doctor was getting upset. I was getting upset. The court stenographer, who was there to record all of my questions and all of the doctor's answers, was also getting upset. And in case you didn't know, there's no judge there. There's no jury there. But the doctor's answers represent his sworn testimony, and it carries the same exact weight as if he is testifying at the time of trial in front of a judge and in front of a jury. But now this attorney was being so nasty, so obnoxious, and so obstructive, it reached the point where I simply could not continue. Every single simple question that should not have been objected to, this attorney was objecting to. So you know what I did? I stood up, I said, we're done. We're busting this deposition, which means I am prematurely ending this question and answer session. And now you, the attorney, are going to pay the price for it. Now what does that mean? That sounds like a threat. Well, it's not really a threat. It's simply conveying to the attorney what I'm going to do. So now I tell him we're done. You're being totally obstructive. Your actions are totally improper. And I will ask the court to sanction you and to fine you monetarily. Now, can I do that? The answer is yes, I can ask the court to do that. In this particular instance, the actions by the defense attorney were totally outrageous. They were improper. And now he was preventing me from continuing this deposition as it should go forward. And you should know something else. These depositions are designed to learn information. It's part of the discovery phase of these lawsuits. And the goal here is to learn information, even if the defense doesn't like having to disclose it, even if it's damaging to their case. So yes, I have the opportunity to ask the doctor questions that could be damaging to his case. And you know what? He has to answer those questions. Questions about his opinions, questions about whether he lived up to the standard of care. And the doctor is required to answer those questions. But what happens if instead it's the attorney's actions that's preventing me from getting the answers that I'm looking for? Well, now the judge can go ahead and fine or sanction the attorney for his improper conduct. And that's exactly what I told the attorney I was going to do. I was going to ask the court to formally review what had gone on during this deposition, provide the court with a copy of the transcript so the judge could actually read word for word exactly what had gone on, and get a sense for what it was like being in this 3 hours of torture where the defense attorney kept obstructing one question after the next, unnecessarily and without any legal justification. So what's the big deal about ending this deposition early? I'll tell you what. If I turn around and say, we're done, I'm busting this deposition, now, technically, I am giving up my right to continue questioning the doctor. And if I have not finished my questioning, I put myself and my client at risk for not having the opportunity to come back and continue questioning him. And that could be a significant problem if I stop the deposition early because of this obstruction, because of this attorney's antics, and now I'm making the wrong choice to end this deposition abruptly. A judge might find later on that no, I had no right to end this deposition early, and because I did, I have now given up my right to go ahead and continue questioning this doctor at a later date. So that's the downside to doing this if I do not have a truly justifiable reason to end this deposition because of what this attorney is doing. So an attorney has to be very careful when ultimately making that decision to stop the deposition. But if I have grounds to do so, and if the opposing attorney is totally nasty and obnoxious and obstructive, then I may have no other choice but to go ahead and end this deposition, put everything on the record so that the court will know exactly what happened, then formally ask the judge to take action against the attorney and to compel the doctor to come back on a different date. So why do I share this information with you? I share it with you because this does happen from time to time. It shouldn't happen, but it does. You get attorneys who are trying to be hotshots, they're trying to look great in front of their clients, they're trying to show their doctor-client that, hey, I'm not just a potted plant, I'm not just going to sit here next to you, I'm actually going to cause a ruckus, and I'm going to cause a lot of aggravation for the other side, so watch the show, watch what happens. No, that shouldn't happen. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fascinating day.